All right, let's look at some implications of the desert constraint. You remember the desert constraint said that we can only criminalize conduct if and to the extent that criminalization and punishment is deserved based on the culpability of the conduct. So implication number one, what's sometimes called the wrongness constraint. It says that we must not criminalize conduct unless it's really morally wrong. So that means innocent or blameless conduct, conduct that's not morally wrong, that has to be protected from criminal liability. So what's morally wrong in this context? What does that mean? At the very least, it requires or can be understood as involving what society, people in the population, generally would regard as morally wrong. Okay? So if a lot of people do not see the conduct as blameworthy or morally wrong at all, then that means that the wrongness constraint would at least plausibly be violated, or at least violated in a way that lawmakers, members of the legislature, would care about. Sometimes criminal law scholars go further. They sometimes restrict the wrongness constraint to not just popular morality, but critical morality. In other words, what moral views you would arrive at if you were trying to systematize common moral thinking, the moral views of people in general, rigorously think about them, reflect on those views, make them coherent, provide a systematic basis for them, unpacking their underlying principles. What's regarded as wrongful according to those underlying principles, you might say, is what's wrongful according to critical morality. This is what philosophers and legal thinkers arrive at. But no one's going to care so much about what a bunch of philosophers say if their views of the underlying principles of morality are very divergent from what the people in the general population see as morally wrongful. So to the extent the wrongness constraint is going to matter, it's got to remain tethered to some extent to what the population, if not universally, because there's never universal moral agreement, but at least generally would regard as the obvious cases of serious moral wrongdoing. Sometimes the wrongness constraint and the moral wrongness in question is restricted even further. A well-known, influential liberal criminal law thinker, Anthony Duff, has made much of the idea that criminalization, to be properly justified, requires not just any old moral wrongdoing or any old moral wrongness, but a public moral wrong. So a moral wrong that is properly the concern of the public. That would be, for example, conduct that violates the core rules of the polity's civic order, a bit of wrongdoing that is a proper public concern because it violates the most serious central rules that constitute the social order. That kind of wrongdoing is a matter of proper public concern and could satisfy the wrongness constraint because it's a matter of proper public concern. That's another way to understand the wrongness constraint. In any case, the connection to the desert constraint is clear. We must not punish innocent conduct because it would be unjust and unfairly interfere with all of our individual right to freedom. That's the wrongness constraint. Implication number two, principle of what we might call the principle of proportional punishment. Jeremy Horder, who is another influential legal criminal law scholar, he put it this way: this principle says that any punishment should be proportionate to the gravity of the wrongdoing, to the harm it causes and the blameworthiness of the conduct, the disrespect that it shows or the lack of concern that it shows for others. So we don't want to punish conduct disproportionately to the wrongdoing, the seriousness or the blameworthiness of the conduct. Why? Well, because disproportionate punishment is similarly unjust. Even if the conduct is a little bit morally wrongful, to vastly overpunish it would similarly be unfair. Take a really simple example. A teenager steals a 50-cent pack of bubble gum from the local grocery store, right? That's bad. Shouldn't do that. That's theft, right? It's a relatively low level harm under circumstances that seem not to be the worst. Maybe it's the first time it's happened. Suppose you criminalize that conduct, that might very well be justified, but suppose you criminalize it and punish the person who did it for throw them in jail for 20 years. I would suggest that it's quite uncontroversial that that would be vastly disproportionate to the degree of culpability and wrongdoing at stake. So to vastly overpunish, to disproportionately punish, would similarly violate the desert constraint. Even if there's a little bit of wrongness, a little bit of culpability that you might say satisfies the wrongness constraint, you still have to ensure that the punishment that the defendant faces is deserved. And to do that, you have to make sure that they're not disproportionately punished, that they're not punished vastly out of proportion to the degree of culpability or blameworthiness in what they did. Implication number 3. I want to draw attention to something called inchoate liability. This is criminalization and punishment absent your conduct being harmful. Sometimes the criminal law does criminalize inchoate behavior, conduct that is not harmful. Implication of the desert constraint number 3 is that inchoate liability, punishing without harm, should be done sparingly and only for very serious forms of wrongdoing that still have some form of proximate, close, direct relationship to tangible harm or serious culpability. Clear examples are attempts to harm, so shooting at someone and missing, taking a swing at somebody's face and being blocked, right? That can be fairly regarded as a crime, even if no physical harm or psychological harm ensues, right? Endangerment, similarly. Fraud can similarly be criminalized even if you don't succeed in tricking anyone into giving you your money, right? So those kinds of inchoate crimes where you can have punishment absent harm, there are some, but we should do it sparingly because there's a risk that inchoate liability involves disproportionate response or undeserved responses by the law. So we've got to be very careful where inchoate liability is concerned, that we don't punish blameless conduct, and that we don't punish disproportionately to the culpability of the conduct. So some dicey examples here that merit careful scrutiny are what are called pre-preparatory offenses, merely getting ready to attempt a crime, but not having actually started the attempt yet. Defiance of the law as such, so just not listening sufficiently to the criminal law and trying to dodge the rules, that can be culpable. But similarly, we all try to stay out of trouble, and sometimes that's okay. So in those kinds of borderline cases, we have to be really careful about criminalizing inchoate conduct that isn't harmful. And that's an implication of the desert constraint as well.